All right. This evening we have three speakers with us. We're honored to have three speakers with us: Kenneth Egger, Ann Lesser, and Patrick Tatum. Thank you all three of you for making it out this evening and being here. We are honored to have you here. I'm going to give very brief bios. This information was presented with the invitation, obviously is on our website as well. But very briefly, Kenneth Egger is the Vice President, Labor Employment and Elections of the American Arbitration Association. He oversees the operations, development, and panel of arbitrators for the labor and employment arbitration caseloads in Pennsylvania, New Jersey, Washington, D.C., and Virginia. Ken has been with the AAA since 1983 and served as Vice President for more than 30 years. Thank you so much for being here, Ken.
My pleasure.
Ann Lesser is also Vice President, Labor, Employment, and Elections with the American Arbitration Association. She oversees the labor and employment caseload interacting with AAA's clients who file labor and employment cases and the panelists who serve as arbitrators and mediators in those cases in New York, Massachusetts, Connecticut, Maine, New Hampshire, and Vermont. Additionally, she oversees the AAA's election services in those states and is engaged in outreach and educational programming in those states as well, and also co-chairs the AAA's Diversity and Inclusion Committee, which is what we'll be hearing a lot of today. So welcome, Ann, and thank you. Oh, and you are muted, Ann. You are one we want to have unmuted.
All right, thank you.
Of course. And Patrick Tatum, again, Vice President, Labor, Employment, and Elections Division, the Western Case Management Center of the AAA, located in Fresno, California, which would be much nicer than I think most of the places we're in right now. He has been with the AAA since 2000, serving as a case manager with the Western Case Management Center, Assistant Vice President of the Neutrals Education with a focus on conducting and observing AAA training programs. He's a supervisor of finance and national customer service and supervisor of the labor and employment caseloads in the Western Case Management Center with the AAA. So thank you, Patrick, for being here today. Appreciate everybody.
My pleasure.
And I'm going to go ahead and hand it over to, I think, Kenneth to start us off today.
Yeah, I'm going to share my screen, so let's hope that works. Can everyone see the screen?
Yes.
Yes.
Okay, great. Pat, are you just seeing the slide there, Pat?
Yeah, I can see the screen, but you need to put it in slideshow mode.
Got it. All right, I think we are good. So let me get started here. So good evening. As indicated, my name is Ken Egger. I'm a Vice President in the Labor, Employment, and Elections Division of the American Arbitration Association. And it's not only my pleasure, but my colleagues' pleasure to present this evening to the Central PA LERA chapter. So for those attendees, and I know most of the people, so I'm really thrilled. So hello to everyone, all my colleagues and friends that I've known for years. So looking forward to this evening. I want to give a special thanks to Rob Barron for the invitation this evening and all that he's done for this chapter. I know he's worked very hard. So as I mentioned, I've brought along two colleagues with me tonight, Ann Lesser and Patrick Tatum. And what we plan to do this evening is provide information associated with an overview of the AAA's labor, employment, and elections divisional activities. We're going to focus on case statistics, new developments, organizational and divisional diversity updates, as well as recruitment and considerations for serving on the AAA's labor or employment panel. As indicated, Ann is going to talk about diversity this evening, and in addition to her various AAA responsibilities, she co-chairs the AAA Diversity and Inclusion Program. And I thought it would be beneficial to have Ann tonight to talk about the various AAA diversity initiatives and the numerous high-level accomplishments. And we do focus on metrics as an organization, and I think you'll find that we're probably one of the leaders in the ADR field with regard to diversity and inclusion. So I think that will be great. Patrick Tatum, we call him Pat. As indicated, Pat is in our Fresno office. and he oversees the division and management of activities in the Western Case Management Center. I brought Pat along tonight because he has a wealth of experience, and he's going to provide an overview this evening associated with the AAA's employment book of business, trends, and all things employment related. So we look forward to that. As indicated in my bio, I oversee labor, employment, and election activities for the AAA in New Jersey, Pennsylvania, Washington, DC, Maryland, and Virginia. Basically, my responsibilities cover the gamut from assisting with case management issues, marketing, educational programs, as well as recruitment of arbitrators and mediators. And we're going to talk about that tonight because we are in an active mode trying to recruit new panel members, especially on the labor and employment side. So we'll talk about that. So let's start with some exciting news, and let me get to my PowerPoint here.
And you should just be able to tap it. Yep, there you go.
You should probably see it. You guys have it there?
Yes.
Okay. So some exciting news. India Johnson was the AAA president for 11 years. She recently retired in January 31st of this year. And we have a new president, Bridget McCormick. Bridget started February 1st. And Bridget is starting to get used to the AAA, but a couple of fun facts with regard to Bridget. And I'm calling her Bridget instead of Judge or Your Honor because she specifically told us that that's what we should do. And it was kind of odd for all of us because, you know, when a new president is hired, we're trying to figure out what we need to do as an organization and how we should address her. So, you know, that's something we got over very quickly. I'm having an issue. Hold on one second. I'm sorry with my power. Oh, there we go. Thank you. My PowerPoint just clicked in on my end. Okay. So Bridget McCormick, as I mentioned, she started with us February 1st. We've gotten over the hurdle of what to call Bridget. If you see her, it's Bridget McCormick. She comes with a substantial background. Bridget served as a Supreme Court justice under the Whitman administration for the Michigan Supreme Court, which is in and of itself a significant accomplishment. A couple fun facts about Bridget. Her brother, William McCormick Jr. is an actor, executive producer, and screenwriter in Hollywood. And her sister, Mary McCormick, for those Howard Stern fans, she played Howard Stern's wife in Private Parts. So we have someone who's connected to Hollywood with us right now. So some of the things that I want to focus on, the American Arbitration Association, we were founded in 1926. We are a not-for-profit organization. And when we were founded in 1926, it followed the enactment of the Federal Arbitration Act. And the specific goal of the association was to help resolve disputes out of court. One of the major issues that I think is overlooked is the fact that we are a not-for-profit organization, and many people are surprised about that. And I think this is a very important fact because this is a factor that distinguishes the AAA from other providers. And it clearly indicates our only role and function as an organization is to help parties resolve disputes. We have no interest or financial incentive in making a case go longer or take more time. So that's very important from our perspective. In 2022, the association administered close to 40,000 cases from our core caseload. And I have a list here. Hopefully you can see that. Commercial is a large book of business, and we typically see cases that range in the hundreds of millions of dollars or billions of dollars. Just last week in New York, we had a Boeing matter that lasted 3 weeks, finished last week, and they were with us 3 weeks, so it was a $6 billion dispute. Construction is also a large book of business, just over almost 4,500 cases, about 600 international, and you'll see there's opportunities for employment where we have about 6,400 cases. And we have a significant consumer caseload, about 15,000. So if you haven't been tapped to serve on our consumer panel and you have some experience, that's another opportunity for you. And our labor caseload in 2022 is about 4,700 at this point. So I do want to share some statistics that I think are pretty important, pretty relevant to the organization. We don't have the current breakdown for 2022 with regards to the type of disputes, but in 2021, we had about 5,000 labor cases, and you can see the breakdown here. Still, a large portion, about a quarter of our cases are discharge related, and then we have the standard contract interpretation, discharge, and COVID was a large book of business for us, obviously, during the pandemic and even now. One of the factors that I think are very important, and Patrick and Ann and I all focus on this, is case administration is so important. You'll note that the median number of days from the time we receive a demand, send out the list of arbitrators, and fill an appointment is only 23 days. And I think that's a testament to our case managers, many of whom you've worked with. A lot of times we see a case filed, and based upon the filing alone, it generates dialogue, conversation, and we see settlements occur in a median range of 187 days. So that means half those cases settle before 187 and half beyond. So again, we see that trend. Once a case is filed, it opens dialogue and hopefully gets to resolution or some other type of means of settlement. Filing to an award, it's about a year, 283 days, just under. And I think, this includes very complicated matters, but I would say on average that we're probably in the 4-month period, 5-month period for cases to be resolved and awarded by an arbitrator. And our panel, as I mentioned before tonight, one of the major goals for us too is to have people start thinking about serving on our panel. We have a labor panel right now that consists of 612 individuals. So there are opportunities. So when COVID hit, it's ironic, we were starting to develop a AAA internal business continuity group. And I served on that group, and we were looking at options, scenarios that we would put in place in the event we had a catastrophic issue or disaster, hurricane, and we've worked with hurricanes with our Miami office, but whatever the case may have been, and then COVID hit. But I could say it's a testament to the association, because almost immediately under India Johnson's leadership, our president, we supported our entire staff with laptops. We provided training and educated individuals to serve as Zoom champions. And I'm sure many of you have worked with our case managers for a Zoom champion to facilitate Zoom hearings. Since the pandemic, we've had 1,108 virtual hearings, 192 of which 17% the AAA has had some type of involvement, whether it's just a connect only or providing full service to the entire process. With regard to our labor panel, in 2022, we added 12 new panelists, 5 of which are diverse, and that's about 42% of the new panel members. And Pat's going to talk about the employment, but we had 38 new employment arbitrators, of which 16% were diverse. Now, with regard to applying to the AAA panel, I'm going to focus on the labor panel. Some important criteria, and I can provide this if someone's interested after the fact, just place your name in the chat and I'll take care of that, or you can contact me after the presentation. But we're looking for individuals who are qualified. They've either served as advocates, they're well-renowned in the business field, or they're basically individuals that have worked in other industries, but can be trained to provide labor management services. What we're looking for, again, individuals with a great deal of experience, but there's one criteria that is always a problem. Individuals cannot be an active advocate for labor or management and serve on a AAA panel. So that's obviously a hurdle for a lot of people. But again, it's something that we want you to consider if you're thinking about retiring, or if you're in a different profession and you want to get involved in becoming a neutral. There's a lot of opportunities. I know here in Philadelphia, we run a training program for newer arbitrators in conjunction with the National Academy of Arbitrators. We run a salon training, and basically what that is, we invite new arbitrators to come in, we invite advocates, and we have a roundtable discussion. Experienced arbitrators, like here in Pennsylvania, we had Walter True and Martin Brogan provide case scenarios, presented them to the arbitrators, and the advocates had an opportunity at that point to ask additional questions, get a feel as to how an arbitrator, this individual, may interpret a potential dispute. So that information is available. It is not an easy process. In order to apply, you're going to have an individual provide a letter of nomination. Once we receive that letter of nomination, we're going to review your application, and then we're going to ask you to provide a packet which will identify 9 references, 3 on the management side, 3 on the union side, and 3 arbitrators. Another thing that we do that it's apropos and goes hand in hand with becoming an arbitrator is we run educational programs. As in 2022, we ran 23 live labor educational webinars based on 5 programs. I've listed those here. And we're always looking for not only advocates, but for individuals who are arbitrators or thinking to be arbitrators, but have the expertise to assist in moderating a program. And that's always a great idea to get your name out there, recognition, and to move forward and advance in the field. One of the other things that I do, I wear a couple hats for the association. I run national elections, and it's a significant book of business. We run into very, very contentious matters at times. We run into issues where we've had issues in New York City over the years, where we've had to call police and had security guards. We had issues with threats and knives and all the things that make the job very exciting for sure. But some of the services that we offer as an organization, we provide mail ballots, online, telephone voting, and in person. 70% of our elections are still by mail ballot, and we use, as I mentioned, 5% are online, interactive voice or telephone voting, 1%. Well, we just developed and completed a new online telephonic voting system internally, and we've seen significant increase in the number of cases or elections that have been sent to the AAA for administration. So I will provide some statistical information in a few minutes related to that, but it is a book of business that is it's booming for the association. Last year we had a record year, and I'll provide some stats in a few seconds here. So here's an example of a ballot. We can provide a ballot in various languages, and we are requested to do that on many occasions, but we have the flexibility and the knowledge to do that. When I talk about technology, so this is just an example of a ballot that in the old days, for example, you can see that you can vote for up to 48 individuals. There are about 150 candidates. In the old days, we'd have to check each box. First, we'd have to check and make sure that the number of votes didn't exceed 48. And then after that, we would have to tally manually. I would think that the results manually would be about 65% to 70% accurate. We now have a scanning technology that we've used for about 30 years. We work with a vendor in New York City. They've worked with the US Census. And again, they can tabulate this ballot. Let's assume it was 10,000 ballots. In the old days, it would take a week to 7 days. The new technology provides us an opportunity to get this done in an 8-hour day. And again, we've been using this technology for about 30 years now, and it's been phenomenal. And this is just an example of our staff in New York City. well-trained, and this was during COVID where we didn't stop or put a hold on elections. Many clients continue to contact us despite the COVID restrictions. We moved to some of the New York elections to more favorable states with less COVID restrictions, and we completed hundreds of elections during COVID, to the surprise of many of the other election vendors in the area. So this is just an example now of an online election ballot that's designed internally, it's programmed internally. There are various fields that are programmed to allow voting. If you vote for additional candidates, it'll pop up and indicate you've overvoted, give you an opportunity to change that vote, and won't proceed forward unless you make your corrections. We have advanced technology with regard to our new online system. We provide what's called blockchain. It's one of the most sophisticated encrypted systems available. We have been running elections with our new system for about 2 years now. Touch wood, we've had no issues, no complaints, no concerns with regard to our accuracy or security. Again, if you look at the screen here, you'll see a ballot, and that's basically a ballot that's prompted to our scanning vendor and ultimately reviewed by the tech and ultimately sent to the computer for verification. We promote, we go back here, we spend a great deal of time promoting AAA elections. We're in the process now of creating a new marketing campaign that will be finalized probably in the next couple months. Some of our high-profile clients include the National Football League, the NFL Players Association, Basketball Screen Actors, and the American and AFTER. It's funny, we conducted, and some of the sports fans might be familiar, the last NFL PA players contract vote was conducted about 2 years ago. And I was heavily involved in that process. It was done online. And the voting period ended, but ultimately the parties agreed to extend the period. At the conclusion of the initial voting period, and no one knew the results, the difference between accepting and rejecting the contract was 1 vote. So it was pretty significant. Thankfully, the margin was much wider after the voting period was extended with the same outcome, so we didn't have any issues. Quick overview, in 2022, our election department conducted 245 elections, of a wide variety of elections, including mail ballot, in-person, online, telephone. 110 of our elections in 2022 were online elections. 42 contained multiple ballot iterations, and 68 with some type of unique variation. And one of the most stats that I'm most proud about is that last year we mailed out close to, well, over 1 million free ballots, and 233 ballots were returned. It's very important to make sure that the process is clean, it's clear, there are no issues. It's so easy to make a mistake in mailing out ballots. And to touch wood, we did not have any issues mailing out over 1 million ballots, and there's a significant amount of liability for the association if we do make a mistake. So we have to be very, very careful. And a last point before I turn it over to Patrick to talk about employment. As I mentioned, we've seen throughout the entire election AAA book of business significant growth. One area where we've seen a great deal of growth is with regard to representation elections. We're finding out that a lot of parties are entering into neutrality agreements, unions and employers, to try to expedite the processing of card checks for representation elections. And one of the main reasons the parties are doing that is the board, the National Labor Relations Board, takes quite a bit of time, and they have a great backlog, as we all can understand and respect. But as a neutral organization, we have the staffing and the ability, trained staff, to conduct these elections in a quick, expedited manner. And again, this is a book of business that we've seen a great deal of growth. About 10 years ago, I worked with the AFL-CIO, and I created, along with General Counsel at the AFL-CIO, what we call a representation panel. And these are arbitrators who have experience in dealing with projects, representation elections. And if you have any expertise in this area, again, feel free to let me know, and I can discuss what we're looking for and potentially provide an opportunity for you to serve on the panel. With that, Pat, I talked long enough. I'm going to turn it over to you.
Okay, Ken, just click on that for me.
I will, absolutely. Let me get there.
Yep. So while we are getting to our employment information, and Ken, why don't you go ahead and go to the next slide? That way we can have all of the stats up.
Okay.
But before I get started, it was really important for me to connect with the Central PA chapter. And so I figured the best way to do that is to tell all of you that I'm sure we all agree that we all wanted Jalen Hurts to have at least one shot at the end of that game. I know that I did. And
Yeah.
so as a group, please know that I am with you. So please, open your arms and accept me as one. That's the first thing I wanted to go over. So the infographic that we have here is for our employment cases. And just like under the labor category, these are going to be numbers from 2021. We don't have the specifics in for 2022 yet, and it'll be interesting to go over.
Ken, can you put that on slideshow? So
Sure.
let's go. Thanks.
Let me get to that.
Okay.
Go, Pat, you can go. I'll jump
Yeah.
in there. Let me get to that.
So in looking at the numbers, one of the key numbers on that infographic is the number of employment core cases that were filed. And we do make a distinction between our core arbitration cases, which is basically individual cases, versus multi-case filings, which have multiple cases filed with the same employer and different individuals. Okay, so what's important for me to point out to all of you is that in these numbers, because we're dealing with such a volume of cases, we have 5 different centers that administer these employment cases. So each of these employment staff report to me. Oh, you're going too far, kid.
Yeah, I got you. Sorry, having a problem.
Okay.
I get there. Absolutely.
Okay. So we've got the Western Case Management Center in Fresno that has most of the Western states. We've got our Central Case Management Center that's located in Dallas, Texas. We've got our Northeast Case Management Center located in Johnston. Our Southeast Case Management Center in Atlanta, Georgia. And then our AAA ICDR New York headquarters also houses some of our employment staff that administers cases. That can be challenging, to say the least, to try and monitor cases all across the region in different areas. It presents some unique challenges in terms of dealing with case law, especially anything that the provider has to deal with. And just offhand, in being in California, we have very unique, statutory requirements for cases, whether it be for payment statutes or disclosures, for arbitrators. So I will say this: in any event that you receive some type of notification from a case administrator and they want you to serve on a case that involves California law, make sure you are extremely familiar with the requirements that you may have to serve under. Obviously the rules, but the requirements for California cases are vastly different from the rest of the country at this point. We do have some instances where, say like in New Jersey, there are statistical reports for consumer and employment cases that we need to provide online and make sure that parties have access to that information. So, there are other states that are taking a look at California law and seeing maybe some of those things could be helpful for consumers and employees, but it does present definitely a bunch of hurdles. So when we look at this pie chart, one of the things we are proud of is the fact that 73% of these cases that were filed, they settled prior to hearing. And we like to think that we have a very big role in that, because when you come to the AAA and we are administering cases, it's not just a laissez-faire approach to managing the case. We make sure that the arbitrators engage with the parties. We make sure that our case owners are engaged with the parties and the arbitrator to keep the case moving along. Obviously, there are going to be times where there's party agreement or a need for a case to be placed in abeyance or postponed. But for the most part, we want to make sure that it's not just a matter of a case sitting around and nothing's going on the case because we haven't looked into it. So we really feel like, and we've had some comments to that effect from the parties, we really feel like once we are involved and making sure that all of the deadlines are being met and sending our reminders and requesting information from the arbitrator and parties during the life of a case, that allows the case to continue to move forward. And once things are getting done on a case, parties have more opportunities to settle, whether it's after the initial conference or whether it's after discovery has been completed and parties have a better idea of the, obviously the arguments on both sides, and they feel like, okay, then maybe this gives us an opportunity to settle this matter without moving forward. And I'll throw out another thing, and it's just the truth. Sometimes it's a matter of preparing a correct and accurate invoice for an arbitrator who says this is the time that's going to be needed for us to continue this case. We provide those estimates to the parties and they feel like, all right, well, maybe we can settle this matter now that we see what the figures are going to be for arbitrator compensation as well. So we give them a different opportunities along the life of a case in order to settle. We also, see whether or not they're interested in mediation, multiple opportunities or multiple stages of the case, so that parties know that we are here to try and help them reach resolution and not just sit around and wait for something to happen. The other number you'll see on here in the bottom left corner, and one of the things that we are proud of is that we waive, just completely waive. We're not requesting any type of payback. The employee administrative fees in a lot of cases. And so for the 2021, it ended up being $27,355. This is one of our missions. Again, Ken said that we are not for profit. And so, we're not trying to have a financial gain in these things. We want to make sure, obviously, that our business continues. But there are going to be times when we need to recognize that in order for someone to have access, someone being individual employers or consumers, to have access to ADR, we will have to waive, administrative fees for them to be able to continue within the process. Ann's going to talk about diversity a little bit more in this program, but I would be remiss if I didn't highlight that our roster on our employment side being 44% diverse and our diverse appointments being 46%. We have a much more representative panel to that of the public. And we know that our colleagues are striving to do the same. So it is something that's very important to the AAA. Next.
Where will we go, Pat?
I was just saying the next slide.
Yeah.
Okay.
You would be here.
Oh, okay. Let's stop here real quick.
Yep.
So again, this is just in terms of the filings. You see that our individual filings, 3,333. Our top states, you know, rah, California, but that's because of all of the different laws that are in place right now. We also have, obviously, Pennsylvania's there, New York is there as well. Now, when we look at the top 10 industries, though, I expect that when we have our 2022 infographic, probably the first 4 or 5 are going to remain the same. They'll probably be shuffled, though, in order, just due to situations still, you know, being completed from the pandemic. So that will be interesting to see. In taking a look at our median times from filing to award, when it says that 4 months, the AAA employment quickest one, that's definitely a rarity, but it's something that we love to see. If we can get a case in the door and get it to resolution within 4 months, everyone's, you know, everyone's engaged, everyone's making their best efforts, and, you know, kind of things are in line. The typical case is going to be that 14 months case, 14.1 months. And, you know, that's, we're actually trying to get more in line with labor and make sure that, you know, we get down to maybe something a little bit closer to a year. But of course, one of the things that we want to make sure as well, though, is that there is the full discovery that's needed in these cases. So we don't want to get in the way of that. We're not pushing our arbitrators to say, you know, you need to get these cases to award in a faster manner if that entails, you know, evidence not being presented and discovery not being completed. Next slide, Ken.
You know, Pat, I threw you a curveball. I made some changes, so I don't know what slide we're looking at.
I'll just talk about anything you have on the screen. We'll be fine. And if not, I'll say, hey, kid, why don't you jump in? I think you need to go back to the one you were just on in terms of publications, right there.
Okay,
so let's talk about publications and education. We always like to promote the Dispute Resolution Journal, and there are some Dispute Resolution Journal volumes that focus specifically on employment. For example, volume 76 here has a few different topics that were specific to employment, you know, the employment law implications of a remote workplace, unlike anything else, the unique nature of employment mediation. I would say that it's, I guess we're all kind of biased here on the phone. It's one of the better volumes that they put out when they focus on our employment. And, you know, we as a group at the AAA, we take a lot of pride in our employment division and making sure that the topics are relevant, the topics are trending, and that people understand that we are paying attention to what's happening out there. And we are trying to make sure that we educate people not only on, you know, the trends, but also, again, ADR itself. You would be amazed at the number of people that we talk to. We talk about the American Arbitration Association, and then we start to talk about, hey, you know, mediation services and other things. And they say, well, wait, you guys are the AAA. We didn't know that you did mediation. So, you know, there are times when we feel frustrated and we know we still have some ways to go, but making sure that we provide, you know, different types of opportunities, different types of entry points into ADR is very important to all of us, because at the end of the day, resolution is the most important. What's the next one, Ken?
Yeah, Pat, I think in looking at the time, we probably, the last thing, Pat, if you could touch on is opportunities for the employment panel and the criteria quickly. Sure. That would be great. And then we'll turn it over to Ann and have her jump in. So thanks. So
when I think Ken had indicated that he would send out the criteria for the labor panel for all of you on the phone, and hopefully, you know, we'll also attach the criteria for the employment panel as well. We don't have the same issue as labor that you can't be an advocate. We are always looking for quality panelists for our employment panel. One of the main criteria is having 50% of your practice be involved in employment law. You also have to have at least 10 years in the employment field. We are focusing on not only diverse panelists, but we also really have tried to take a stronger look and make a better pitch to the plaintiffs panel. We've had difficulties with recruitment on the plaintiff side because, for a long-standing while, they've always wanted to be in court, but we try and show the statistics and show the numbers and try and convince the plaintiff panel that joining us would help go a long way with making arbitration stronger, providing better selection and an even panel of selection for parties who are involved in ADR, instead of some of the plaintiffs' bar having a false impression that all we do is send out management people. We have judges, we have plaintiffs' bar, we also have management people, but we know that we do need to recruit on the plaintiffs' bar more heavily. So,
Absolutely.
with that said, let's go with Ann.
Thank you, Pat. And we're going to turn it over to you with regard to the AAA's diversity and inclusion initiatives.
Thank you, Ken. I'm going to share my screen. And give me 1 second. Okay. Can everybody see that?
Yes.
Okay. Yes, Ann.
Okay, so good evening, everybody. Thank you so much for inviting me, Ken, to participate. I'm excited to tell everybody about all our diversity initiatives. As Ken mentioned, besides being a vice president at AAA, I'm also co-chair our Diversity and Inclusion Committee. And I think what some people may or may not know is that AAA is not new to the whole area of diversity in ADR. Actually, our commitment goes back to the 1970s. And back then, AAA co-sponsored the first National Women's Arbitrator Development Program to establish a method for recruiting and training qualified women arbitrators. In addition, the first diversity programs to increase women and minority arbitrators was in the labor arbitration area. And this included large unions and companies as co-sponsors, along with AAA and the FMCS. So there are, three groups at AAA that demonstrate AAA's ongoing commitment to promoting diversity. So we have the AAA Diversity and Inclusion Council. This is made up of people who are outside of AAA, and it's also made up of arbitrators, as well as some AAA staff, including myself, my co-chair, and Sasha Carbone, who is our Associate General Counsel. And this council is responsible for providing advice and recommendations to the AAA to increase diversity and inclusion of women, minorities, and other individuals and groups that have historically not been included in meaningful participation in the ADR field. And then we have the AAA Diversity and Inclusion Committee, of which, as I mentioned, I co-chair. This is a long-standing committee that coordinates initiatives. We promote events, we collaborate with firms and organizations to increase awareness of the benefits of diversity and inclusion in ADR. And then additionally, there's an internal committee called the Ideas Committee, Inclusion, Diversity, Equity, Acceptance, and Support Employees Resource Group. Quite a mouthful. So I think that's why they shortened it to the acronym. And they provide resources and opportunities for staff to build and strengthen cultural awareness, sensitivity, and understanding, and unite and harness diversity and experiences to forge stronger connections with colleagues. So additionally, as you may or may not be aware, increasing AAA's panel diversity is part of AAA's corporate and executive goals, and as well as divisional goals for each division and for executives across every division and region of AAA, and all executives work to actively recruit women and ethnically and racially diverse candidates who meet the criteria for the AAA and ICDR panels. And additionally, we also focus on our mediation panel as well, but we also look for diverse panelists to speak in educational programs and to represent AAA in publications. So we did a review of our listings in 2022, and we noticed that on average, our lists across all divisions average 34% in diversity. So back in many years ago, and I don't have the exact year, but I'm trying to find this, and nobody seems to be able to give me this date, but quite a number of years ago, AAA established our goal of generating lists of arbitrators that were at a minimum 20% diverse. To our knowledge, we were the first arbitral institution to incorporate a minimum diverse list requirement into our case management administration. And the goal was to generate arbitrator lists that were at least 20% diverse or more in terms of gender or race and ethnicity. To track our progress, we set and achieved organizational goals to have 90% of lists of proposed panelists created by the AAA to be at least 20% diverse. However, in 2023, based on the fact that we've noticed that our lists were really over 30% diverse, on average 34% diverse, we decided to formally raise the threshold from 20% to 30% to better reflect our practice, and also to communicate that we are committed to a minimum of a 30% diversity in arbitrator lists. Another area that we have expanded for 2023 is we have actually expanded our diverse categories to include not only race, ethnicity, and gender, but also disability, gender identity, and sexual orientation. So moving forward, those will also be included. So slide 3 reflects the status of our panel in 2022. So by the end of 2022, our panel was 30% diverse. And it's important to note that this number has actually steadily been improving every year, from 25% in 2017 to 30% in 2022. 41% of the new additions to our roster in 2022 were women and racially and ethnically diverse. So this little chart here, I think, is interesting. So actually, it shows you how the numbers have gone up. Percentage of panelists are diverse, 25% in 2017, to 26% in 2019, 27% in 2020, 29 and 21, and 30 and 22. So as you can see, it is moving up. The increments are small, but it's moving in the right direction, and the numbers are moving up. But I think we also want to make sure that we're not just putting diverse panelists on our panels, but they're also being appointed. And so this number on the second line is also very important. And there again, you see it moves from 25% in 2017, 27%, 2018, 29%, 2019, 31% in 20, 32% in 21, and 35% in 2022, which is a 3% jump from 21 to 22. Now, this is just my personal opinion, but I think this jump of 3% is really reflecting that the message is getting out there to those who select panelists regarding diversity. And so therefore, I think that's really increased the number of appointments. But again, my personal opinion. So this slide shows the percentage of diversity within each division, but I'm actually going to move to the next slide because I like the visual here. So you see that we have 30% of our, well, almost 31% of our commercial division is diverse, 20% of construction. That is traditionally difficult to find diverse arbitrators in the construction area, 44% in our employment division, 34.7% in labor, 35% in ICDR, and 35% in the consumer division. employment is, I think Pat pointed out earlier as well, is really at a very high level relative to the other divisions. AAA is also, the ICDR is a signatory to the Equal Representation in Arbitration Pledge, which affirms a commitment to increase the number of women arbitrators into the international dispute resolution field. And ICDR does maintain and make publicly available those statistics, the number of women arbitrator appointments in ICDR arbitrations, and the number of women in the ICDR roster. So across the board, whether it's in the legal field, the ADR field, or any other field or industry, obviously there's clearly much more work that needs to be done on the issue of diversity and inclusion, or I should say the lack thereof. And so this is why AAA really continues to enhance our outreach efforts, engagement, and programs in order to reach, recruit, educate, and inspire diverse students, associates, partners, judges, and professionals in general who have an interest in ADR. This in turn will increase the number of qualified diverse arbitrators and mediators. And so in 2022, these are a number of the organizations that we reached out to. And our outreach efforts included everything from organizing, presenting, sponsoring, facilitating workshops and training. And we continuously work to build connections and nurture relationships with local bar associations, law schools, and trade groups around the country on diversity and inclusion initiatives. So as you can see, this included the National Bar Association, NAMWOLF, ABA Margaret Brent Awards, NAPABA, MCCA, and the National Hispanic Bar, Women in Dispute Resolution, and the New York Law School Diversity Symposium. Besides these national efforts, our executives also focus on efforts in their regions. And so there are other events and other conferences that we might sponsor where a regional executive knows what's happening in their area. For example, you know, if you're in Houston, you might know about what's going on there, or, you know, Miami, etc. But if you go to our website, you'll actually see we have an even larger list of organizations that we sponsored over the years. So, but I also, what I want to mention is that with several of these organizations, we have had partnerships that actually extend beyond simply sponsorship, and that's what we want to focus on. It's about partnerships. It's about working together in the synergy with other organizations. So one of those organizations is the NBA, which is the National Bar Association. This is the nation's oldest and largest network of predominantly African-American attorneys and judges. And it represents the interests of approximately 66,000 lawyers, judges, law professors, law students. And we've been heavily involved with the NBA for decades, providing information, education, and resources. We continued this in 2022 by facilitating interactive workshops and designed to better equip practicing neutrals with the skills essential to ethical mediation and arbitration practices. We did this at the organization's annual convention. NAMWOLF was founded in 2001. That's the National Association of Minority and Women-Owned Law Firms. It's a nonprofit trade association with a mission to promote diversity in the legal profession. The AAA regularly collaborates with NAMWOLF on recruiting initiatives for panels, providing information, education, and resources for their members. I'm actually going this weekend to San Diego for their conference, where we will have an information session on getting onto our panel. And then we hope in September, when they have the national conference, we'll be able to provide a training that will happen alongside or right after that conference to help those people move faster onto our panel. And finally, we have supported the Margaret Brent Awards for a number of years. This is an amazing, I must say, event. If you ever have the opportunity to attend, these women are amazingly accomplished. I feel very inadequate every year when I watch and listen to all their accomplishments. And it's a very inspiring event. So we also look at pipeline projects and look to see how we can reach up and coming diverse professionals and law students. And so one of the programs that we have that was established in 2009 is the Higginbotham Fellows Program. So in 2009, AAA launched the Higginbotham Fellows Program, which was named for the Honorable A. Leon Higginbotham Jr., who was the first American District Court judge for the Eastern District of Pennsylvania, and the 7th African-American appointed as an Article III judge. AAA created this program in order to provide training, mentoring, and networking opportunities to up-and-coming diverse ADR professionals who have historically not been included in meaningful participation in the field of ADR. In 2021, we actually refined the program and introduced a new format, beginning with a self-study component, which spanned over several months, and this was then followed by a 4-day intensive training at AAA's New York offices. To date, approximately 150 fellows have actually graduated from the program, and we are now holding our 2023 program in May. So there'll be another 20 fellows, so that number will increase to 170 fellows. But we also have almost all fellows who have applied to AAA's rosters have advanced to the roster, and I think to date that number is around 51. So the program has fellows from 24 states, Washington, D.C., Puerto Rico, Virgin Islands, Ghana, Kenya. So it really has been a very successful program. And after the 4-day intensive training, the fellows are then linked with a mentor for the year, and we follow up with other programs and educational programming that we offer for free to the fellows. However, in 2019, we decided we needed to go even further back than the Higginbotham Fellows Program, and we conceived of something called the Diversity Student ADR, the Summit. So in 2019, we launched our inaugural 1.5-day ADR Summit for diverse law students to provide an understanding of what it really takes to become a successful arbitrator and/or mediator. And the idea was to step back even further from our Higginbotham Fellows Program and to talk to students, because there's a lot of ADR programs today in law school, and students are under the impression that they can walk out, after graduation and hang their shingle up on June 1st and become an arbitrator or mediator, and it really doesn't work like that. So we wanted to give them a very realistic view of what it takes to become an arbitrator or mediator, and what being an arbitrator and mediator actually entails. And how to orient their careers if this is their end game. And we were fine if after the weekend somebody walked away and said, wow, that whole arbitrator mediator thing wasn't what I thought it was. That was okay with us too, because we really want them to understand what it takes to be a mediator or arbitrator and to move their careers in the right direction, because you can't be an immigration lawyer for 30 years and then say, I want to arbitrate employment disputes or other commercial disputes. So if this is what you want, we want to direct you in the right direction. We held the program in 2019. We held it again in 2022. We had a bit of a hiatus due to COVID because we wanted it to be in person. We had both times a very large pool of applicants from around the country and overseas. Each time we accepted 20 students. We've had students from all over the country and from Mexico and Argentina and Australia. And AAA provides the students with a $1,300 stipend to cover travel expenses, because we really want to make sure that this is open to everyone. We had several panels of diverse ADR professionals, and each panel provided the students with a different perspective, from telling us their personal journeys to discussing what attributes are needed to become arbitrators and mediators. We had a panel of general counsel, we had a panel of litigators, and a panel of our past Higginbotham fellows. Feedback from the students from both years was overwhelmingly positive, so we were excited about that. One more area I'd just like to tell you about is the AAA ICDR Foundation Diversity Scholarship. So the Diversity Scholarship is funded by the AAA ICDR Foundation through a special gift from the AAA, and the fund provides diverse law students and professionals with up to $2,000 of financial assistance toward participation in a degree program or fellowship in alternative dispute resolution, or attendance at a well-recognized conference. The mission of this scholarship fund is, of course, to encourage diversity inclusion within the field of ADR by supporting the pursuit of knowledge and skill development through training experiences and encouraging inclusive leadership growth in the field of ADR. So I think last year they gave out almost close to $39,000 in scholarships. We have applications coming in all the time. If you know somebody who could benefit from the scholarship, have them go to the AAA ICDR Foundation website, and they will be able there to find the application. It's a very simple process, and I encourage you to let people know about that. So, as you can see from all of this, we've been very busy working on diversity, and we continue every day to try to improve and to try to work harder at it. And that's the end of me for today. And I'm gonna.
Yeah. I think. Catherine or Rob? Yeah.
Ken, is there something I guess at this point, I guess I'd ask if anyone has any questions for Pat, Ann, or Ken. I know we've run over a little bit, but I think it's certainly been well worth it, and we started a little late as well. But any questions for Ann, Ken, or Pat? So I do have one. So I know when, Ann, you did touch on this in terms of diversity, but do you break down, when you're talking about diversity, you're talking about your percentages as both includes women, racially and ethnically diverse, is that correct?
Well, the percentages I've given you include those categories only, because we expanded the additional categories starting in 2023. So yes, those statistics that I gave today would include gender and ethnically and racially diverse.
So do you track, I'm just curious as to whether or not how much expansion there's been on the racially and ethnically diverse side? Because I know that there's been some discussion in terms of how can we grow, how can we get more inclusive in that respect as well? And I'm just not sure whether that's something you guys track separately, or you're seeing improvement there, or if you're seeing more of the improvement perhaps with more women entering the field and being more greater acceptance.
Yeah, no, we are seeing improvement in all areas, including the racially and ethnically diverse areas. I don't have those statistics separated out, but there is an improvement there. I'm thinking, actually, in the back of my mind, I think there's been approximately a 2 to 3% increase in racially and ethnically diverse arbitrators.
Okay. Thank you. Any other questions?
This is Deborah Wallet. I have a question. What is the difference between your labor panel and your employment panel?
Ken, you want it, or you want me to say it?
You can take it.
Okay, well, the easiest way for me to describe it is that our labor cases are cases related to collective bargaining agreements. So anything that falls under a CBA it should be under the category of labor. With our employment cases, you'll have a variety of different agreements, but none of them are going to be under a CBA. You'll have individually negotiated. You'll have independent contractor cases, or just in employment agreements, and all of those would fall under the in employment area.
Thanks, Pat.
Yep.
Any other questions? Well, first of all, I'd like to thank Kate for stepping in. I'm actually traveling today, and she's been great to jump in and take and run with this. Ken and Pat, thank you for a really interesting presentation. I've certainly learned a heck of a lot more about AAA than I realized was out there. So thank you very much. So I can't clap, because if I did, I'd drop my phone. But if we can give Ann, Ken, and Pat a hand. With that, unless Kate, Chris, anything you want to add?
I have nothing new to add, Chris.
Nope, I have nothing new to add other than a reminder about shutting off the recording.
Thank you.
All right. Well, thank you very much. We've got an April meeting, and we'll get something out in the next week or two with respect to that next April meeting. We're going to do that virtually. And then our hope is to have our final meeting in May, an in-person meeting. We're going to look at something that someplace perhaps a little different than we've had in-person meetings before. But if at all possible, we'd like to pull some folks in, get everybody together for a farewell for the season at our May meeting and do that in person. But with that, I just want to thank everybody for taking the time to join us. And again, Ann, Ken, and Pat, thank you so much for your time.
Thank you for having us.
Thanks, everybody.
Pleasure.
Thank you.
Thanks,
Yeah,
guys.
thanks a lot. Appreciate
Thank you very much. Good to see you all.
it. Thank you.
See you, everybody.